Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Welcome, everybody. My name is Lisa Stam. I'm co-presenting with my colleague, Jessica Paglia this morning. Good morning, Jess.
Morning, Lisa. Thank you. Welcome. Good morning, everyone. My name is Jessica Paglia. I'm an associate lawyer here at SpringLaw, and I'm really looking forward to chatting about remote work with everyone today.
Awesome. So we are both employment lawyers on the team. Thanks, everyone, for joining this month's webinar on remote work, liability, home office compliance, and best practices. For those who are new to our webinars, we are a virtual Canadian law firm specializing in employment, contracts, law, and litigation. This topic is near and dear to my heart. I founded the firm back in 2017, pre-COVID, with a vision of a solely virtual firm. And together we've all built out these systems and an infrastructure that really supports our virtual community with connection and compliance, but all with this client first only approach. So, you know, we love talking about the systems we've built out, the legal issues that arise from all of this that we, you know, observe through our clients. So I'm excited to talk about this topic today. Throughout the session, if any of you have any questions, please just throw them into the chat. And we will try and get to them when we can, either at the end or during. You could also download the slides themselves under the handouts tab. And then for more resources, just come to our springlaw.ca website. And there you will find our award-winning weekly blog, a link to subscribe to our monthly newsletter and to this monthly webinar, and then info on our subscription program for employers and some of our DIY legal products. Okay, let's get started. Here's a thanks to Emma behind the scenes, our producer, who makes these beautiful slides for us. Okay, over to you, JP.
Thanks, Lisa. So I'll just go through a land acknowledgement before we start. We're virtual today, but we're based in Toronto. So we acknowledge that the land on which we operate is the traditional territory of the Anishinaabe, the Haudenosaunee, and the Huron-Wendat and Mississaugas of the Credit First Nation, who have stewarded these lands for generations. We recognize that Indigenous people lived and thrived here long before the arrival of settlers, and we acknowledge that the lasting impacts of colonialism. As part of our commitment to truth and reconciliation, we strive to learn, unlearn, and understand the history and effects of these wrongs, and we're grateful to live and work on this land. And so next we will have just a legal disclaimer, of course. I won't read it to you, but we encourage you to just take a moment to review the content on this slide.
Okay.
And so with that, we will jump right into our introduction. So today we're talking about remote work, and remote work is not just a COVID trend. It's very, very obviously here to stay. Although the world fast-tracked into remote business in recent years, tons of businesses have realized that they can move a lot of their work to remote and that there are a lot of benefits associated with doing so. And while the tech has kept up, sometimes and oftentimes we see the legal and operational strategies are not always in line with what's needed for this entirely new work dynamic. And there are real compliance risks in how people work remote today. And we're going to go through some of the key things to consider as far as liability and compliance today. And we're also going to be outlining some key contract terms, how to handle some extra provincial and cross-border issues. We're also going to get into the health and safety obligations and how to manage performance remotely. And then finally, we'll leave you with some best practices to support your team while also protecting your business. So now I will pass it over to Lisa to outline remote work revolution.
Okay, thank you very much. As JP mentioned, you know, we're in the post-COVID world, and working remote itself is not novel, and so some of these comments will be things that everyone is already living and breathing in their workplace. So having the option for some amount of remote work is expected by more and more employees. Obviously, we're not talking about surgeons or people who are drilling oil. Like, obviously there are lots of jobs out there where you just need to be tactical and hands-on, and so a lot of our comments are not for every workplace, but for the whole world of knowledge workers, this shift from in office centric management and infrastructure and policies to more distributed teams is really shifting how we deal with all of the how we run workplaces. Obviously, there's some benefits. It's great for a broader talent tool. Our lawyers are all over the province, so we're able to just find people in different communities, different perspectives. It adds diversity to the team, but it also allows companies in general to really broaden their overall talent pool. There's risks. What I like to think of as how you do things differently in the remote world. You do need to manage differently. You cannot micromanage and breathe over someone's shoulder because you're not watching the input in that tactical, physical way. So the whole way that things are managed is going to look different. There are some legal gray zones around if people are working remote and they're off, in Costa Rica for 3 months. What does that look like from a legal perspective? And we'll talk about some of the cross-border issues. And then, there could be some operational gaps. There's going to be new things that need to happen and some things that can drop off as a result. So there's always this updating and looking at what's new in the modern workplace. So the legal landscape for remote work. Let's just touch on some of the overall issues. First of all, what is a workplace? And I think a lot of these issues really started to hit when social media first came out. It's only a decade ago. It feels like a lifetime ago for many people. But there was a whole issue of if someone posts something crummy on their Facebook page, is that the workplace? And so this idea of expanding the workplace beyond your physical desk in the office is not new at this point. And so when we look at what is a workplace and what laws apply to it, it's wherever work is happening. So whether that's channels in a Slack group, if it's off hours because you're being asked to attend an event, if it's off hours and you're using the workplace computer and you're working, all of that is still work, even if it's not in office. And so all of these different rules will apply. So for example, in Ontario, the Employment Standards Act and really all the workplace standards across the country in the 14 jurisdictions, the key rule is where the employee is living and working is what employment standards will apply to them. So that really is a core factor to always be thinking about. It's not where the employer is. So we will have clients, for example, where the headquarters are in Quebec, and one of their employees is living and working here in Ontario. Very different laws apply because of the language rules, and then just Quebec has its civil law system instead. We always pull in our colleague Vincent, who does our Quebec employment law in that case. And so we're looking at this cross-border issue. But if that employee of that Quebec-based company lives and works in Ontario, then the Ontario Employment Standards Act will apply, as will the Human Rights Code of Ontario, OSHA, and various safety issues will all apply. Now, what happens in the world of health and safety if the person is working from home? And this is where I think in the early days of remote work, there was some ambiguity around this. But at this point, if your employee is required to work from home as part of their job, then all those same proactive duties exist for employers where health and safety obligations of the employer apply. So think ergonomics, mental health. If there's isolation and it's leading to low productivity, what are things that the employer can do to help if this starts to tip over into mental health? Now you're looking at a human rights accommodation. So there, and we'll be talking a lot more about that in a moment. Just a very quick note for people listening in from Ontario. We have two pieces of legislation that do apply. If you have a workplace with more than 25 employees, then this disconnecting from work policy will apply. It doesn't create new rights, but it does set clear expectations, or it requires employers to set clear expectations around when people are expected to be available in the workplace. So it's if you have more than 25 employees, you need to have this policy. Again, it doesn't mean that people have an automatic right to not work past 5. It's just a right to know what are the expectations. The electronic monitoring policy also comes into play and is quite relevant for the remote workforce, I think. Again, it only applies if you have more than 25 employees in Ontario. In this case, the policy through the ESA says that if you are conducting any electronic monitoring of your employees, you must disclose that to them. So it's not banning employers from being able to do so. It's just that transparency is key. And if you are deciding to do any sort of electronic monitoring. Whether you should do that is a whole other question. I'm on the side of the fence, do as little as possible because it breaches trust. Nobody wants you snooping in their emails, but you do need to manage your workforce as well. So there are ways to get visibility on what's going on without overtly spying on your employees all the time. So but that's a whole other webinar for sure. Jessica, over to you.
Thanks, Lisa. So now we will go through some key contract terms for remote workers. And these are some things that companies should know about and consider when establishing or maintaining a remote work contract. So the first thing is work location and recall rights, if any. So even for remote roles, as Lisa kind of, encapsulated what is the workplace, you should also define the official work location within the contract. So their home, your office, another province, whatever that location may be. This matters for tax, employment standards, and jurisdictional recognition. It's important also to have an acknowledgement of where someone has confirmed that they will be performing the work that's assigned. And then in addition, if you ever want to have the right to recall someone into office, even part-time or even changing the metrics of that, however you see that happening should be included in the contract as well. The next thing is hours of work and overtime. So what are someone's defined hours? This is especially important in a remote work environment because, people might be working before or after, but it's good to set a block hour of, this is where we expect that you will be available and working at your desk. Additionally, it's important to mention how and if those hours will be tracked. You can refer to the electronic monitoring policy as well if you're in Ontario. And you should also think about how overtime will be approved and how breaks or availability are going to be handled. So next would be something along the lines of a confidentiality, tech use, and security clauses. These are typical in employment agreements across the board, but particularly as it pertains to remote work, because remote work, because of the reliance of the tech, it increases the risk of these things. So contracts should always, but especially with remote work, have clauses on confidentiality, acceptable tech use, and security. This is especially important if people are using their own personal devices or if they're operating on public Wi-Fi at any time. So the next thing that's important to incorporate is reimbursement or equipment and just defining clear expectations of what's being provided, who is responsible for paying for what. This is important because with remote work, people are not coming into your place of business with the supplies and the devices that you provide them. So they're going to be using laptops, phones, internet, printer ink, paper, pens, things that you don't really consider as essential parts of the business, but these things should be discussed and accounted for at the outset. The last thing that we can discuss now is communication expectations. So people should know, again, when they're expected to be online, what the methods of communications are going to be relied upon to communicate with them and for them to communicate with you as well. So Slack, email, Zoom, things like this. This helps avoid performance issues and supports boundaries on disconnecting as well. And some optional add-ons that you can consider are monitoring clauses themselves with reference to any electronic monitoring policies, any disclosure of that. Temporary layoff language we find is an important consideration with remote work. Any jurisdictional clauses or governance clauses. It's helpful if people are often moving around or if they do work extra provincially. And then, yep, that's a good summary of that. So I'll pass it over to Lisa to expand on these jurisdictional and cross-border considerations.
Okay, great. Thank you. Just one quick point. We probably should have said this earlier. We're really focusing on employee relationship in this webinar. So if you are, many people think, well, if I just set them up as an independent contractor, then I can avoid all this hassle. But you know, because they're working remotely, that I can make them independent contractor. Those are two very different legal issues. If they are truly an independent contractor because they look and smell like an independent contractor, great. But otherwise, you can absolutely have part-time, full-time, remote employees, and all the usual stuff will apply. So just as it occurred to me when you're talking about the reimbursement and equipment provisions, if people are expected to provide all their own tools and pay for all their own stuff, that's typically not the case in an employment relationship, but definitely in a contractor relationship. So just one of those factors that you keep separate when you're dealing with those two things.
Great
And my
point,
last
Lisa.
comment is about communication expectations, because I think, I don't know, Jess, don't you find when you're dealing with, you know, we advise both employees and employers. When we're on for the employee side, almost always it's often a case of broken telephone somewhere along the way. Someone did not communicate to them. They're confused. They didn't meet expectations because they weren't sure what the expectations were. The employer thinks they were crystal clear because like they thought it, but they forgot to tell it. And so just the communication expectations, I don't think we can overstate that. That is just, you know, when should people be coming in to say hello and goodbye? And if they don't, are you going to start inferring that they're not showing up, or they're not trying, or they're not caring, or that they're moonlighting? You know, like it's this communication piece is just in the remote world. I don't think that we can overstate it. We put it right in the contracts for all of the employees. This is what we expect for your communication. We put it right in our remote policy as well, so that people aren't guessing, and then you come into the office with a bit of fun because everyone knows you know, check in remotely and say goodbye at the end of the day and show pictures of what your kids are doing and your cats and everything else.
Yeah, and I
um
would actually, before going too much
yeah,
into a different topic, I would also add it's a great point of communication. And I would add as an employer to write this down somewhere, not just
yeah.
say it once in the orientation, to actually have a policy or
Mm,
something with this kind of outlined or written, a guideline, so that you can
hmm.
also refer to it in any case.
Yes, exactly. Yeah, that's a great point. We have just a couple of questions. So one was, can you elaborate on overtime rules? So in the remote world, it's going to be the exact same thing as the in-person world. Tracking it is a whole other thing. So it depends on the province, but in Ontario, anything over 44 hours is subject to overtime. And if you're going to expect more than 48 hours, it's a whole rigmarole to get special permission and averaging agreements and that kind of stuff. So typically you cap it out at 48. Anything else to add on overtime at all, Jess?
Good.
No? Yeah, okay. I know that Alicia, that was an expedited answer, but it's no different than in the remote world than in person. And then for cross-border, we have a question about that, but I'm going to move to cross-border next. So maybe I'll be answering the question in there. Yes, I will be answering. And yes, the slides will be available after for the third question. Okay, keep going here. So cross-border remote employees. I admit this is where we start to get a little bit above our pay grade as employment lawyers, because this is where tax, immigration, IP law, all of those start to really kick in. The underlying jurisdictional question is, where are your employees physically living and working? And that's what's going to trigger all kinds of stuff. So on the employment law front, the employment standards and human rights laws are going to apply to wherever the person is living and working. But for tax and immigration and IP, first of all, go on our YouTube channel where we've brought in lawyer specialists in these areas, so that we've done some deep dives on these areas that will detail this a lot better than I can. The bottom line is, where your people are living and working may also trigger tax obligations, which and then the cousin to that of payroll compliance obligations. And sometimes it's inadvertent, right? So for example, if you're an Ontario employee and you hire, and let's pretend we're talking about Calgary instead of California. So we're still in Canada. So the immigration laws will not apply in the same way. That's where tax is going to apply. Immigration really only kicks in if you are going outside of Canada. For tax, that is a provincial issue. So if you have an employee that says, hey, I want to move to Calgary, and you're an employer in Ontario, if they work from home there, then employment standards laws will be Alberta, but you're not necessarily setting up a corporate entity in Alberta. And so the tax laws will probably be okay. If that person starts to rent space in Alberta, now you've created an establishment and you may be triggering some tax rules. Again, I am not a specialist in this area at all. So take a look at, we had Anna from Advotax come on one of our webinars and go through all of this in detail. So feel free to check that out on our YouTube channel. I think the bottom line is if you have someone who is moving to a different province, check in with with us or with your tax lawyer to see what's going on. If it's immigration and they're moving outside of Canada, so if we look at the case study example, if you are an Ontario employer, and let's say you want to hire someone who lives in the States, or sorry, you're going to hire someone in Ontario who decides to go move to California for the winter. Again, if they rent a space down there, you might be triggering U.S. tax obligations, and that becomes a dual country issue. But their own immigration status will also start to matter, because you may run into issues in the States where you're hiring someone in the States. Now, if it goes the other way around, where you hire an American who comes up to Canada, just because they have an employer here does not mean they have valid immigration authority to be here. So you still will need to go through all the usual immigration laws to bring that employee up into Canada. And that, you're looking at labor market opinions and a whole application process. Immigration is a highly specialized technical area. I would never dabble in that just because it's so finicky and the government rules change day by day, minute by minute on that. So that is something that we definitely always pull in an immigration lawyer for anything that's cross-border. Each province will have its own workers' comp rules. So Brittany, you asked a question about what happens with cross-border WSIB and workers' comp. Let's say you're an Ontario employer and you have an employee out in Alberta, and you are in an industry that requires workers' compensation, that's always a key factor here, then yes, you will need to look at both provinces and make sure that you're compliant. If you are an office worker, and then there's a bunch of professions that are exempted as well, then not so much. And Jessica is going to talk about that a little more in a moment. For the IP and confidentiality protection issues, the rules that we have here are going to look different in different countries. Moral rights as a concept is just treated differently in Canada versus the US, for example, through the case law. And that is another area where often the stakes are just so high, it can be a real bet the company kind of issue. And so you definitely, if you have key IP that a person outside of your local jurisdiction is dealing with as part of their job, it's a very good idea to get that section of their contract reviewed. We will often just, we work with Michelle Wassner over at Method Law, and often we'll have her just pop in for an hour, look at the provision, and vet it from an IP perspective, so that it's one-stop shopping for people. But definitely the IP piece is also an expensive mistake, and so that's why each of these tax immigration IP we just want to carve out as red flags to always keep an eye on when you're dealing with your remote worker, and issue spot those early on. Okay, Jessica, over to you.
Thanks, Lisa. That was very comprehensive. And next, we'll go over some workplace injuries and liabilities when employees are working from home. And Brittany, just to touch on your question a little bit further, as Lisa said, If the employer is required to register and to have the workplace insurance, we would encourage you to follow up with each province wherein your employees are residing or working to determine whether or not you have an obligation to provide that insurance. It's not automatically portable, and it's not very clear. Every situation could be different, even as it pertains to needing to have coverage. So we encourage you to, do a little bit of digging on your own, and feel free to reach out to us if you have any specific questions. We can help you further on that. So now to get into the workplace and injury and liability topic. If a remote employee is injured at home while performing work duties, the WSIB coverage can apply, and in Ontario specifically, and in other provinces, the applicable coverage, as long as the injury arises out of and in the course of employment. So even if someone is working from their kitchen table and they trip over the power cord during a Zoom meeting, that could be a compensable claim. But something like, injuring themselves during a personal break or outside of work hours or outside of the office, it's likely outside of the scope. And so Lisa went through, what does work related mean, but we'll expand a little bit more on that. And it comes down to whether the activity was part of the job during work hours and in a space set up for work. And so WSIB will consider all of that when determining whether or not to cover the claim. And so do employers, need to register for WSIB for remote workers? The answer is, if you have an obligation to register for WSIB in general, and that's determined through the legislation and through, there, as Lisa said, there are a bunch of excluded and included industries. And so we encourage you to do a little bit of digging and determine, if you haven't already, whether or not you have an obligation. And that obligation would extend to remote workers as well as office workers in the same kind of realm. So Ontario employers generally are required, unless, they're excluded. And so there's no special exemption just because the employee is remote or knowledge-based in their performance of work. So what should the employer consider or do to manage their risk of any claims or of any injuries? You should train staff or circulate training for your staff on remote ergonomics and safe home workspaces. You can provide checklists to help them assess their own hazards in their own space, and obligations as well for completing those checklists, things like cords, poor lighting, bad chairs, and to record those things and address them as they are raised. And then you can create a reporting process so that any incidents get flagged and they're handled properly and immediately after occurrence. You don't need to inspect every home. You just need to take reasonable and comprehensive steps. Think more due diligence on the front end. And so it protects both the employee and the business itself. And so an example of this that we kind of touched on before would be, an employee trips over a cable at home, they get hurt. And so what flows from that, and, how could the employer mitigate any further liability in that instance? So in this scenario, the injury would likely be considered work-related for WSIB claim because it happened during work hours and in the course of employment. And if the employer has provided, say, a home office safety checklist, this would demonstrate the employer's due diligence in that regard. By giving the employees tools to identify and address hazards, the employer shows that they've taken reasonable steps to promote a safe work environment, even though that work environment is outside of the traditional office and outside of their traditional control of the environment. And this checklist can also be important evidence if there's ever a question about liability to do with a WSIB claim or even beyond that. And it shows that the employer made an effort to educate and support employees in maintaining their own space's safety, which can help mitigate risk and fulfill any potential legal obligations in that regard. And so the key takeaway here is that by taking proactive and calculated measures, such as safety checklists, you can not only help prevent injuries, but you can also protect the organization in the event that an injury ever does take place by documenting your commitment to workplace safety. So next we'll talk about a little bit of the difference between WSIB versus long-term and short-term disability, and the duty to accommodate. And so this is something that is a little bit confusing if you're not used to talking about it, or if this is your first time having exposure to it. And so WSIB is workplace safety insurance coverage. It's for injuries caused by work, operative word being caused, and includes remote work as long as it happens in the course of employment. So if someone, twists their back or hurts themselves during a work task, even at home, there's a chance that WSIB will cover it as an injury, a workplace injury. And so with, short-term disability, long-term disability, and any disability accommodation conversations, these things are separate from WSIB, and the coverage and the duty to accommodate, they come into play when they could come into play when the injury or illness is work-related, but also potentially when it isn't work-related. So especially, the duty to accommodate and coverage in that regard, these could be applicable to situations where an employee is recovering from surgery, they have a personal medical condition. It could even be extended to their family and taking care of family in that regard. So that would fall more under the ESA protected leaves. That would fall under your policies leaves and applicability. And then that would also fall under the Human Rights Code and an employer's duty to accommodate and duty to inquire if they feel like anything is going on behind the scenes, or if they're disclosed such. And so it's important to note that even if it doesn't happen on the job, the employer would still have a duty to accommodate under the Human Rights Code in any regard. So it could mean something as, simple as adjusting a schedule. It could be something more complex like modifying duties or organizational roles, or approving a gradual return if that's what's set out as needed. And so we have a ton of online resources that you can look through regarding these topics. We also have a couple webinars discussing these, and you can also feel free to reach out to us with any specific questions as it pertains to employees in your workplace. And so just to go back to the slide, the legal frameworks of these two things are separate, but they both kick in or could kick in depending on how and where the injury occurred. And it's also worth noting that if someone works remotely from another province, the WSIB is not automatically portable. And this relates to Brittany's question from before. And so you might need to register in another province or do some digging on your own.
Exactly. Yeah,
And
we've had
so,
a bunch of time. Sorry, go ahead, JP.
No, that's okay, because I'm going to move on. So feel free.
Okay. Well, I'm just going to make a note. We often will have employers who will make their accommodation decisions based on what WSIB said. And Jess is making a very good point here. These are two different legal frameworks. They kick in concurrently, but they're not the same thing. And an employer always has this freestanding, independent obligation to accommodate, regardless of what WSIB may say. So it's just that human rights duty, it's always there. It's always there. And then, there's lots of workplaces that don't have WSIB. And so there's not as much case law on it, frankly, as there is with accommodation issues. But the human rights piece is always there. We have a couple of good questions on this. So Miriam has asked, do the checklists need to be assigned by the employees, these due diligence checklists? What do you think?
Do they need to be assigned? Sorry, I'm just going to,
Yeah,
signed.
signed.
You know what?
Yeah.
It's not essential, but it is, it's not a structured legal obligation of the employer. So it really is up to how far do you want to have this due diligence recorded. If you want to create it as part of your onboarding process, that's always a good thing. Any type of confirmation of, okay, you've provided me the checklist, but hey, I've actually completed the checklist. It's always great just to come full circle and really emphasize that back and forth communication aspect of it. What do you think, Lisa?
Yeah, I agree. I agree. It's this continuum, right? Due diligence is not one thing. It's doing a bunch of things to show your attention to the obligations. And so having the checklist is that alone is fantastic. And having employees fill it out is also fantastic. Whether they sign off on it, I mean, sure that it's always a little bit better, but you know, for many small employers, there's only so many hours in the day. And so I'm always pretty empathetic to as lawyers, not telling everybody to do all the thousand things every day because sometimes it's not possible. But having them sign, sure, that's better. But if it doesn't happen, having the checklist, I think is the key piece. Kelsey has asked a very difficult question, so I don't know if we'll have a great answer for you. How can we be sure if the injury happened during work hours, during work, versus a personal break? I think of someone falling downstairs, going to the bathroom during a workday. How would that be treated? You want to take the first cut at it?
Sure. I think, there's a difference between the employer's assessment of the situation and WSIB. So WSIB will do their own conducting of the analysis. And I think the presumption is typically that if something happens during the workday or on the provisions that we kind of provided as defining what is the work-related measure, the presumption is that it would be a part of, the work and would be covered. But I have no, answer for any particular instance. Every case is decided on its own merit, and the WSIB, adjudicator or whoever is in charge of reviewing that related instance would, have their own assessment protocol to determine that.
Mhm.
Lisa, what do you think?
Yeah, I know. I mean, I think there's case law now about if you go to the bathroom and you hurt yourself on the stairs up to the washroom. I think that is definitely um, part of your workday. But if you pop out to the grocery store to grab a loaf of bread, that would not be covered. But then there's a whole bunch of stuff in between. What if you're running an errand and you're also, depositing a check for the company because that's your role? But then you also popped over to Starbucks to get a coffee. It's we're still early days sorting out a lot of these things. So this is where I knew we wouldn't be able to give a nice cut and dry answer to this one. Where it falls down on either side, personal or work related, it's going to be a very fact driven situation. But some of the basics of, I mean, picture what happens in an office. If you walk down the hallway to go to the washroom, you may be setting up some stuff at your desk and trip over a wire that, or a cord, that definitely will be covered. But then if you're doing errands outside, off work property, then I think that's where it gets a bit the gray area.
I I would
Sorry, go
agree.
ahead. Yeah.
No, I was going to actually read another question if we're
Okay. Yeah, perfect.
okay with
Yeah.
that. So we have another question coming in. Um, is the employer still responsible for ensuring a safe work environment at the employee's home if the employee is not, in quotes, required to work from home, or if the employee has an option to work from home but could work, at the employer's office as well? Lisa, do you want to take a start at it? And then I think we both have a pretty good idea of
Yeah,
this one.
well, I mean, it's if they are permitted to work from home as part of their job, then the employer will have a proactive duty to keep them safe.
Yeah, I
And if you
agree.
don't want them to work from home, then say it, right? Like if you don't want that obligation or that liability, then lay down that rule, basically.
I would agree. I don't think there's a distinguishing factor between whether the employee decides where to work, if it's allowed, in determining the employer's obligations to keep the workplace safe. So,
Mhm.
as Lisa said, if you want to limit that to just your workplace and have more control over the space itself, if that's your concern, then there's a discussion to be had about limiting that ability for the employee to work from home uh, when they want. And
Yes.
that's a good segue into our next slide, which is a little bit more information on home office compliance and, what does that mean, what to consider, what to include as a conversation piece. And so we hear a lot about ergonomics, but the ergonomic setup does matter. And it's you wouldn't be able to see if someone is hunched over their desk for 9 hours a day. You wouldn't be able to, control that. So it's important that the ergonomic setup is considered and is discussed. And so you should encourage employees to arrange their workstations to minimize strain and injury. This includes proper chair height, monitor placement, and keyboard positioning, which might sound arbitrary, but they do make quite a difference. And so it's important to have that conversation. And you can also provide guidance or resources on ergonomics. These can help prevent repetitive strain injuries and other common issues. And so, secondly, privacy and data security remain important, crucial, even at home, and especially at home, I would say. Employees should be reminded to follow company policies for handling confidential information, should very intentionally use secure Wi-Fi and be, um, considerate when they're not able to, when they have to use public Wi-Fi, and to take proactive measures to store sensitive documents safely. Employers may need to provide training on this or tools to help maintain data security outside the office as well. And we actually encourage you to consider providing a little bit more guidance on this, especially at the outset of the employment relationship. And a third thing is to have, clear expense policies. It's important to define what home office expenses are reimbursable, such as, office chairs, monitors, internet upgrades, and communicate this clearly to staff at the outset. And this avoids confusion and helps ensure that employees have what they need to work safely and effectively. And this is especially important in cases where you hire someone that is then transitioned to at-home work. So you're not hiring them as initially as a remote worker. You're moving them either on their own accord, or especially if you move them home to work, you have to really consider, okay, who's going to be responsible for the setup of this person's workspace? And with the consideration of employees versus contractors, as Lisa mentioned before. And so finally, you should maintain regular check-ins, even scheduled if you need them to be, through one-to-ones or weekly meetings especially. And these scheduled check-ins should be to discuss the workload itself, to address any safety or equipment concerns, and to provide ongoing support in that manner. They should be regular and consistent and pre-planned, so you're never letting, 6 months or a year go by without having these discussions. And so regular communications helps identify issues early and reinforces the employer's and the company's commitment to employee well-being and safety. And by focusing on these areas, employers can help ensure that remote work arrangements are both safe and productive for everyone involved. And so next, we're going to talk a little bit about technology and data security, and then I'll pass it off to Lisa to discuss how to build connections in remote culture. So remote work isn't just a logistics challenge, it's also a risk management one. And by that, we mean that when employees are outside of your office network, your business is naturally more exposed. Sensitive data is being accessed from personal devices, home Wi-Fi, potentially public Wi-Fi in public spaces, and the physical space as well. People might be working in a public space, have people looking at their laptop screens, or overhearing calls or things like that. And that's a security problem if it's not being managed and addressed. And so here's what employers should be doing. You should have a secure system. Have employees connect through a VPN or enable multi-factor authentication protocols. You can use encrypted tools. So these are all, it's not a one size fits all, especially with small employers, but these are basic things that you should consider to protect your data from unauthorized access and exposure. Training employees regularly is also a great consideration. Most breaches come from good old human error, clicking a phishing email, downloading the wrong attachment, responding to someone, they shouldn't be responding to, or things like that. So regular short training sessions and mechanisms for reporting issues right when they occur go a really long way in that regard. You should set boundaries around personal devices if that's something that is a consideration for your business and its security needs. And you should decide whether personal laptops or phones are allowed. If yes, they should have some minimum security requirements. So password protection of the device itself, any antivirus if needed, and then remote wiping capabilities as well if required. And so next, you should have an incident response plan. If something goes wrong, if someone loses their device, or if it's exposed um, in some kind of breaching way, or if there's any suspected breach, employees should know exactly who to contact in the organization and exactly what steps to take. And you as an organization should have this outlined as well. What exactly has to be required, legally and otherwise, for disclosure of breach and things like that. And it removes the guesswork in these very, high stake situations potentially, and allows you to just have something to rely on and roll out. And so the bottom line is remote work challenges your risk profile. And so if you're proactive and clear with the employees that you have working remote, you can manage these risks without, affecting flexibility of the work itself. And so next I'll pass it off to Lisa to discuss and supporting employee well-being.
Okay, thank you very much. I just want to go back one step quickly. Ella had a question that we didn't get to, and I got lost in the shuffle. So I just want to answer it now quickly before we move on to this next section. Ella asked if we have a situation where an Ontario-based employee wishes to go to their home country for a month and work remotely from there. For how long is this arrangement allowed by law under Ontario employment standards? So Ontario employment standards is not going to be the big issue. So just to be clear, so let's say you're an Ontario company and you have an employee that's going to go work in a different country for just a month, let's say. If it's only a month, most countries it's no big deal. Especially if they have citizenship there, then it's also no big deal. If you stay longer than a certain amount of time, then tax and immigration issues start to kick in. And in Ontario, I'm not as worried, but the other jurisdiction, I have no clue, what Panama's laws are on this, and so or any that's just one random country. But so you would need to be, check in on the other country. But for most cases, 1 month is no big deal. I know in Canada, once you hit, I'm pretty sure it's 180 days, that it's the tipping point, then things start to happen where you're no longer resident here long enough and immigration stuff happens. So, and then international treaties start to kick in with whose social network is going to kick in so that people aren't double paying into systems. So it's all very complex, but if it's about a month, it's basically a long vacation and they're going to work there. And so usually it's more of an immigration issue on the other side.
Yeah,
Hopefully
and
that,
I will add,
yeah,
Lisa, that
good.
just as the ESA doesn't have set timelines for this,
Mm-hmm.
or doesn't really speak to this, but it does speak to when it applies. And so,
Mm-hmm.
if it's when the work that's being performed in Ontario or the continuation of work outside of
Right.
Ontario, but there are specific, analyses that have to happen in each specific case. It's not really a blanket one size fits all rule, but it is another consideration that potentially if this person on your team is working in another jurisdiction entirely and they're now working from there permanently, or they have no plans to return, or something of that, um, something plays out like that, then there is a consideration as well of which statutes might
Mm.
apply as in lieu of the ESA.
That's a great point. You're right. That continuation of work provision has a timeline on it. So continuation for a bit is fine, but not indefinitely. That's a great point. Okay, let's talk about building culture in a remote team. And law and HR is always a very, very close cousins. So this is somewhere in the middle of that. when you're building your remote team, it requires some intentionality. I think in person it also does, but we traditionally have sort of relied on bumping into each other at the water cooler. But when you're in a virtual team, there's opportunity for more inclusion, more deliberate inclusion, but there's also just some being a little more deliberate about these opportunities. So setting communication norms, we already talked about how important that is. Pre-scheduled virtual team huddles and social time is having that scheduled recurring event, I think is the important thing, because nobody ever has time this week, right? But if you've already built around a schedule, then all of a sudden there's time. So having it deliberately in people's schedule really matters. Have ways to recognize wins, right? In the in-person office environment, you sort of would congratulate each other as you're walking down the hall, but how do you do that in a virtual environment? And that's part of really building this emotional connection to your workplace. Fostering inclusion, I think this is where remote work can really have that secret sauce of bringing in more diversity and more inclusion, because you're deliberate about it and you're not just relying on traditional traditional mentoring that often in a sort of more old school workplace will rely on stereotypes and who do I connect with, as opposed to who needs mentoring. It's a very different approach, and so having this deliberateness is really the key piece around that. In terms of supporting employee well-being, you can't physically see it necessarily, but this is why I think video calls are really so important. You really get to see almost everything you need to see on a video call. You're still seeing some body language, you're seeing facial expressions, you're seeing tension, stress, mood, you're seeing all these things. And so that it allows you as a manager, as an employer, to start to inquire, right? And ask questions. Are you okay? What's going on? Do you need a hand with anything? It allows you to watch for some more burnout signs. If you've got a benefits program, make sure you're promoting the employee assistance programs that will often now contain mental health benefits, and just be open for that conversation in that remote space, and it'll free people up to access some of these things. For performance managing in a remote space, this is where how you look at output versus input, right? So you want to be setting expectations about what is the job you want done, what is the thing you want done, without all the micromanaging. You can't micromanage in a remote setting in an effective way, or any way, because you can't physically see the person. There has to be a little bit of trust, but by defining goals and key performance indicators or KPIs clearly, using a centralized task management system that is in the cloud and has visibility for everybody for that flow of collaboration, giving consistent feedback, and then, as always, performance management. I mean, that's important in every workplace, but I think it's particularly important in the remote space to make sure that you're having that in a regular manner, so that you can really allow for any key issues that might be bubbling beneath the surface to come up, and you have the conversations that allow for it. One last point on this: in the remote space, it does not need to equal lifestyle only. You are still paying people to work, and you're still allowed to manage their performance, and you're allowed to set up specific expectations at the way that you would in a physical office. You are allowed to say, I don't, you can't babysit during your shift. You can't do housework at the same time. That's not part of your job description. It's, people, unless you have some sort of additional accommodation in place for something that is based on a protected ground. But doing laundry during work hours is not a protected ground. So, if they want to do that on their lunch hour, that's fine. But, post-COVID, we have a lot of high stress in the workplace as people sort of still really get their feet back on the ground after such a traumatic couple of years for so many people. But I find a lot of employers feel like they're walking on eggshells, unable to just set expectations for their remote workplace, but there's no different than if you were in person. Okay, some remote work policies essentials.
Which is a good segue from setting expectations, which is the purpose of a remote work policy, and not only to set clear expectations, but to reduce your legal and operational risk. So these are some key areas to cover, things that we've already discussed today. So I'll run through them quickly, mindful of the time. Who's eligible to work? Not all roles or departments may qualify. So whether you define it by job function, performance, operational needs, this helps prevent fairness across the board and prevents any pushback. Work hours and availability should also be defined. You should set clear expectations in addition to an employment agreement, in the policy itself, core availability windows, how quickly people are expected to respond, things like that. Keep everyone aligned and ensure coverage in any event. Equipment expenses, we've delved into this, but it's always good to echo, what the policy is. And then confidentiality IT as well, we've dived into that, so I won't, go through that very extensively. And then when remote status can change. So this should be in the employment agreement, but can be echoed in a policy as well. You should be upfront, business needs change, and if you need the availability to call people back into a home base, you should outline what that looks like and when. And yeah, that's pretty much what we've outlined. So a clear, updated remote work policy, protects the business, supports your team. It also prevents any future headaches when things do arise, and they do. And so now I'll pass it over to Lisa after that quick review to bring us home with some practical tips and some best practices going forward.
Okay, thank you. So let's finish on what actually works on the ground, right? I mean, in our webinars, we're always trying to make sure that we're not just reciting legal principles, but also practical tips. So, if you're still sort of on the fence about whether to do this, try piloting it with a smaller programs or a smaller group of people so that you can get a sense of what works. Gather real feedback and then iterate. So surveys and real-time feedback, not just once a year. Staying current on law and tech updates. So what things like the remote work policy, or sorry, the monitoring policy that came out. Just keeping an eye on what might be out there so that you're able to stay very up to date and be able to roll out tools that are compliant. Leading with trust, not control. And self-awareness is a gift that few of us have. We all are, especially owner operators. You really want to make sure that your brand and your company is functioning and pushing forward your vision. But you're also not employing a bunch of robots, and people have different ways to contribute to the team. And so leading with trust, I think, is just such an important piece. Checking in with people as people, whether or not they're remote or in person. Obviously, stuff happens, and so asking personal questions, appropriate personal questions, is part of how you build engagement and check in on people's mental health. And then, really laying out clear expectations about what people can and cannot do. I think that's our last main slide, but I wanted to get to Leon's question because I think it's a good one. Any thoughts on how often team huddles or meetings should happen to maintain culture? In a small, busy group, weekly isn't practical. So there's definitely no right answer to this. It really depends on your company, how big your team is, what sort of management structure you have in place. If you have a lot of salespeople that are out on the road, then certain things might not even work. But certainly any business books I've read, any business coaching I've been in, there is that rule of thumb that try not to have more than 5 direct reports and meet with them weekly, because that way you can knock off things in half an hour instead of it blowing up into a full day event. And so for your direct reports weekly, for other people, I have one person in my firm who I don't work directly with very often because she's in the other legal hub within our team, and she works with some other lawyers. But we realized, we never interact otherwise, so we just have a recurring monthly call so that we just stay in touch, because otherwise it's Shannon. Otherwise we wouldn't talk to each other. And so we just have a monthly call, and there's always stuff to talk about for sure. So I do think having that regular recurring call, more, I would lean on the side of more recurring and shorter than less frequent and longer, because then you can knock off issues. Jess, do you have anything to add to that at all?
No, I think that was great coverage of and great answer. Yeah.
Okay. Well, everyone, it's 11:30. Thank you for the great questions today. Really appreciate it. I know that remote is it feels like it's not new anymore because of COVID, right? It was such a novel thing pre-COVID, but there's just this ongoing issues that we're all working out together still. The case law is still coming out on a bunch of things. So thank you very much. Our next session is going to be in January. We're taking December off from the webinars this year. And the next one will be looking at the 2026 legal landscape for small businesses, what every HR pro and in-house lawyer must know. So we're just going to do a forward-looking session on what are the major employment law changes coming up and trends to prepare for. So it's sort of a beginning of the year, get ready for the year kind of session, and that will be in January, third Wednesday of the month. We always do it. If you have any further questions, here's our team of lawyers and clerks, so please feel free to give us a call. Come to our website, springlaw.ca, for any, we have our blog and information and resources there. Follow us on social for updates. And I think that's all for today. We'll see you in the new year.
Thank you, Lisa. Thank you, everyone.
Thanks, Jess. Bye, everyone.